Good day, everyone. Republic Act Number 1123 to Revise Corporation Code of the Philippines. Title 6 Meetings, Section 48 to 58. Section 48 Kinds of Meeting. The meetings of the directors, trustees, stockholders, or members may be regular or special. Section 49 Regular and special meeting of the stockholders or members. Regular meetings shall be annually on the fix in the bylaws, but if not fixed, the date shall on any date of after April 15 of every year, and provided that the notice of the meeting shall be sent at least 21 days prior to the meeting through email or such other manner as the Commission shall allow under its guidelines. At each regular meeting of stockholders or members, the Board of Directors or Trustees must present to stockholders or members the following: the minutes of the most recent regular meeting, which includes a description of the voting and vote tabulation procedures used in the previous meeting, a description of the opportunity given to stockholders or members to ask questions, and record of the question asked and answer given, the matters discussed and resolution reached, a record of voting results for each agenda item, a list of the directors or trustees, officers, and stockholders or members who attended the meeting, and such other item that the Commission may require in the interest of good corporate governance and protection of the minority of stockholders. There be a members list of non-stock corporation and for stock corporation material information on the current stockholders and their voting rights. There C, a detailed, descriptive, balanced, and comprehensible assessment of the corporation performance, which shall include information on any material change in the corporation's business strategy and other affairs. Third D, a financial report for the preceding years, which shall include the financial statement duly signed and certified in accordance which this code and the rules of the Commission may prescribe, a statement on the adequacy of the corporation's internal controls or risk management system, and statement of all external audit and non-audit fees. The E, an explanation of dividend policy and the fact of payment of dividends or the reason of non-payment thereof. Next, director or trustees profile, which shall include, among others, their qualification and relevant experience, length of the service in the corporation, training and continuing education attended, and their boarding representation in the other corporation. A director or trustee attendance report indicating the attendance of each director or trustee at each of meeting of the board and its committees and in regular or special stockholder meetings. Appraisals and performance reports for the board and the criteria and procedure for assessment. A Director of Justice compensation report prepared in accordance with this code and rules of Commission may prescribe. Director's disclosure on self-dealing and related party transaction, and the profiles of directors nominated or seeking election or re-election. So, in the meeting, a director, trustee, stockholder, or member may propose any other matter for inclusion in the agenda at any regular meeting. So, in the special meeting naman, shall be held at any time deemed necessary or as provided in the bylaws. Pero, the notice shall be sent at least one week unless a different period is provided in the bylaws. A stockholder or member may propose the of a special meeting and items to be included in the agenda. So in the notice naman, it may be waived by any stockholders or member. So in the general waivers of notice in the articles of incorporation or the bylaws shall not be allowed, and attendance at a meeting shall constitute a waiver of notice such meeting except when the person attends a meeting for the express purpose of object. So there is no person authorized. A person authorized unjustly refuses to call a meeting. The stock and transfer book or membership book shall be closed at least 20 days of the regular meeting and 7 days for a special meeting before the scheduled date of the meeting unless the bylaws provide a longer period. In case of postponement of regular meeting, a notice and reason must be sent to all stockholders or members at least 2 weeks prior to the actual date unless the bylaws provide a longer period. The right to vote of stockholders or members may be exercised in person through a proxy or when so authorized in the bylaws through remote communication or in absentia. The mission shall issue the rules and regulations governing participation and voting through remote communication or absentia. Section 50. Place and time of meetings of stockholders or members. So the meetings shall be held in the principal office of the corp, if not, in the city or the municipality where the principal office is located. Notice of the meeting shall be sent through the means of communication provided in the bylaws and shall state the time, place, and purpose. And the notice shall include the agenda for the meeting, a proxy form which shall be submitted to the corporate secretary within a reasonable time prior to the meeting. When attendance, participation, and voting are allowed by remote communication or in absentia, the requirements and procedures to be allowed when a stockholder or member elects either option, and when the meeting is for the election of directors or trustees, the requirements and procedure for nomination and election. All proceeding and any business transacted at a meeting shall be valid even if the meeting is improperly held or called, provided that all the stockholders or members of the corporation are present or duly represented, and not one of them is to object to the transaction of any business because the meeting is not lawfully called or convened.
Section 51. Quorum in meetings. Unless otherwise provided in the Revised Corporation Code or in the bylaws, a quorum consists of the stockholders representing a majority of the outstanding capital stock or a majority of the members in case of non-stock corporations. Thus, for stock corporations, the quorum is based on the number of outstanding voting stocks. Take note, based on number of outstanding voting stocks for stock corporations, while for non-stock corporations, only those who are actual living members with voting rights are counted in determining the existence of a quorum. To be clear, the basis in determining the presence of quorum in a stock corporation is the numerical equivalent of all members who are entitled for vote unless some other basis is provided by the bylaws of corporations. Section 52. Regular and special meetings of directors or trustees. Unless the articles of incorporations or the bylaws provides for a majority of the directors or trustees as stated in the articles of incorporation shall constitute a quorum to transact corporate business. And every decision reached by at least a majority of the directors or trustees constituting a quorum except for the election of officers, which shall require the vote of a majority of all the members of the board, shall be valid a corporate act. Regular and special meetings of directors or trustees. Regular meetings shall be held monthly unless the bylaws provide otherwise, while special meetings may be held at any time upon the call of the President or as provided in the bylaws. Regular or special meetings of directors or trustees may be held anywhere in or outside the Philippines unless the bylaws provide otherwise. With respect to directors' regular meetings, notice should now be served within 2 days, at least 2 days, instead of only a day prior to the meeting unless otherwise fixed in the bylaws. Directors or trustees who cannot physically attend or vote at board meetings can participate and vote through different alternatives. In SEC Memorandum Circular Number 6 dated March 12, 2020, if a director or trustee intends to participate in a meeting through remote communication, he or she shall notify the presiding officer and the corporate secretary of his or her intention. Such fact should be included in the minutes of the meeting. Take note, however, that the revised corporation code allows only the directors or trustees to meet through teleconferencing. It does not provide for a similar authority to the stockholder or members. A director or trustee who has potential interest in any related transaction must recuse from voting to the approval of the related party transactions without prejudice to compliance with the requirements of Section 31 of this code. Section 53. Who shall preside at meetings? In the old code, it was stated there that only the president will preside of all the meetings, while the revised corporation code, it was stated here that the chairman or, in his absence, the president shall preside at all meetings of the directors or trustees as well as of the stockholders or members unless the bylaws provide otherwise. Section 54, Right to vote of secured creditors and administrators. In manners of voting, a stockholder or member may vote directly or indirectly through a representative of: first, by means of proxy; second, by a trustee under a voting trust agreement; and lastly, by executors, administrators, receivers, or other legal representatives duly appointed by the court. Voting may either straight or cumulative. Section 55. Voting in case of joint ownership of stock. Section 55 requires the consent of all co-owners in order to vote such stock. Such consent is not necessary where there is a written proxy executed by the joint owners, authorizing one or some of them or any other person to vote for all, and the shares are owned in an capacity by the holders thereof, in which case any of the joint owners can vote said shares or appoint a proxy therefore.
So now we will proceed to section 56, voting right for treasury shares. It says here that treasury shares have no voting right as long as such shares remain in the treasury. Why? Because in and of itself, treasury shares doesn't have much value. treasury shares do not pay any distribution. That's why they do not have a voting right. Next is section 57, manner of voting proxies. Sige. So, it says here that stockholders and members may vote in person or by proxy in all meetings of stockholders or members. So, stockholders and members, pwede maging proxy in all the meetings of stockholders or members also. Stockholders and members may also vote through remote communication or in absentia when so authorized in the bylaws or by a majority of the BOD. So, pwede pala mag-vote through remote communication. What is remote communication, by the way? The remote communication is a communicating at a distance via electronic tools that let you correspond with the people outside of face-to-face communication. So, katulad sa ating ginagawa ngayon, virtual communication, it is considered as remote communication. And it also become a quintessential part of the business world. But it must be authorized in the bylaws or by a majority of the BOD or the Board of Directors. Stockholders and members na nag-participate through in absentia or remote communication shall be deemed present for purposes of quorum. So, they consider those who participates in remote communication as present sa kanilang meeting para makaabot ng quorum. So, even though they are not there physically in the presence, the meeting, they are still deemed present para sa purpose of quorum. So next here is corporation. Corporation shall establish the appropriate requirements and procedures. So kailangan ang corporation ay may appropriate requirements and procedures for voting through remote communication and in absentia, as what I have said earlier. So, taking into account the company scale, number of shareholders or members, structure, and other factors consistent with the basic right of corporate suffrage. So, it says here also that proxies shall be writing, signed, and filed unless otherwise provided in proxy forum. So, ang proxy shall be writing, signed, and filed by the stockholder or member in any form of authorized in the bylaws and received by the corporate secretary within a reasonable time before the scheduled meeting, unless otherwise provided in the proxy form. So, unless otherwise, nakaprovide siya sa proxy form. And it shall be valid only for the meeting for which it is intended. Hindi na siya valid kapag lumagpas na siya sa 5 years at any one time. Next, let us proceed to section 58, voting trust. So, one or more stockholders create a voting trust of a stock corporation. So, pwede siya makakreate ng voting trust for the purpose of conferring upon a trustee or trustees the right to vote and other rights pertaining to the shares of a period not exceeding 5 years at any time, provided that in the case of voting trust specifically required as a condition in a loan agreement, said voting trust may be for a period exceeding 5 years but shall automatically expire kapag ma-full na ang payment sa loan. Ang voting trust agreement, pwede siya ma-write and notarized and shall specify the terms and conditions thereof. A certified copy of such agreement shall be filed with the corporation and with the commission. Otherwise, the agreement is hindi na siya effective and unenforceable na siya. So, ang certificate or certificates of stock na covered by the voting trust agreement shall be cancelled and new ones shall be issued in the name of the trustee or trustees, stating that they are used pursuant to said agreement. So the books of the corporation shall state that the transfer in the name of the trustees or the trustee is made pursuant to the voting trust agreement. It says here also that trustee or trustees execute and deliver to the transferors voting trust certificates, which shall be transferable in the same manner and effect a certificate of stocks. Voting trust agreement filed with the corporation subject to examination by any stockholder. So thereupon shall be bound by all the provision of said agreement. So, it says here also that any other stockholder ay pwede makatransfer ng shares to the same trustee or trust. Another voting trust, no voting trust agreement shall be entered into for purpose of circumventing the laws against anti-competitive agreements, abuse of dominant position, anti-competitive mergers and acquisitions, violation of nationality and capital requirements, or for the perpetuation of fraud. Unless expressly renewed, all the rights granting in a voting trust agreement shall automatically expire at the end of the agreed period. So, pwede siya ma-renew, pero automatically ma-expire din siya at the end of the agreed period. So, the voting trust certificates as well as the certificates of stock in the name of the trustee or trustees shall thereby be deemed cancelled, and new certificates of stock shall be reissued in the name of the trustors. So that's it. Next is trustee or trustees may vote by proxy or any manner authorized under bylaws unless agreement provides otherwise. So, the voting trustees, pwede din sila makavote ng proxy or any manner na authorized pa rin under sa bylaws unless agreement provides otherwise. So that's it for the section 58.
Now let's proceed to Title 9, Merger and Consolidation. So first, the definition of merger and consolidation. So merger, the absorption of two or more corporations by another existing corporation, which retains its identity and takes over the rights, privileges, franchises, and properties of the absorbed corporation. The absorbing corporation continues its existence while the life or lives of the other corporations is or terminated. So sa merger, merong absorbing corporation and merong ding absorbed corporation. Yung absorbing corporation, yung kanyang existence ay mananatili at iti-take over niya ang rights, privileges, franchises, and properties of the absorbed corporation. While yung mga absorbed corporation naman, or corporations, ay mati-terminate ang kanilang mga life or lives. So, yun. Next is consolidation. Is the union of two or more corporations into a single new corporation. All the constituent corporations thereby ceasing to exist as separate entities. So, sa consolidation naman is yung dalawang corporation or higit pa sa dalawang corporation is mag-unite sila para mag-give rise sa another new corporations. So yung mga lives ng constituent corporation or mga original corporation ay ma-extinguish or mawawala na at lahat ng mga rights, assets, properties, liabilities ay mapupunta doon sa new corporations na nabuo. So, examples. So, sa mga cases, like example sa merger, A plus B is equals to B or A. So, yun. Pwedeng isa sa dalawang corporation yung manatili at yung isa is mawawala. While sa consolidation naman, A plus B is equals to C. So, both ng constituent or original corporation ay yung life nila ay ma-extinguish at makaka-form ng another corporation. So, yun. So, according to RCC Section 75, two or more corporations may merge into a single corporation which shall be one constituent corporations or may consolidate into a single corporation which shall be the consolidated corporation. So, ano nga ba yung mga procedures for effecting merger or consolidation? First, approval of plan of merger or consolidation. The next is stockholders or members approval. So, sa approval of merger or consolidation, the board of the directors or the trustees of each corporation party to the merger or consolidation draw up and approve a plan of merger or consolidation. Yung mga board of directors or the trustees is sila yung mga ng bawat corporation is sila yung magdo-draw up ng plan and of course, i-approve nila yung plan of merger. Paano ba natin masasabi na okay or approved na yung plan of merger? It shall be approved by a majority vote of each of the board of directors or trustees of the constituent corporation. So, dapat majority ng vote ng mga BOD or trustees sa bawat corporations, yun, majority nun is agree sa plan of merger or consolidation. Another one, ano yung mga nating dapat malaman is kung ano yung contents ng plan of merger or consolidation na kailangang set up ng mga board of directors. First is yung names ng mga corporation na nag-propose ng merge or consolidate. The terms of the merger or consolidation and the mode of carrying the same into effect. Then, a statement of the changes, if there is, in the article of corporation of the surviving corporation in case of merger, and in case of consolidation, all the statements required to be set forth in the article of incorporation for corporations organized under this code. And last, such other provisions with respect to the proposed merger or consolidation are deemed necessary or desirable. It is under Section 75. So, let's proceed to procedure number 2. Stockholders or members approval. So, kailangan yung plano hindi lang sa board of directors isa-submit or i-approve. Dapat i-submit din ito sa mga stockholders or members para sa ng bawat corporations para sa kanilang approval. So, ito ay mangyayari, magpapatag sila ng separate corporate meetings duly called for the purpose with the proper notice in the same manner as giving notice of regular or special meeting under Section 49 of this code. So, here, kagaya ng gaano ka-importante yung approval ng Board of Directors, ganun din ka-importante yung approval ng stockholders or member. So, sa pag-submit nila ito, magpapatag sila ng separate corporate meetings na hindi ito siya kagaya ng mga ordinary corporate meetings ng isang corporation. So, tinatag itong meetings duly called for the purpose. So, kagaya ng mga regular or special meeting is kailangan din sila magbigay ng notice. And sa notice na to, according to Section 76, the notice shall state the purpose of the meeting and include a copy or summary of the plan of the merger or the consolidation. So, sa notice nito nakastate kung ano yung purpose ng meeting and include dito yung copy or summary ng plan of the merger or the consolidation. So, paano ma-approve yung plan? So, affirmative vote of the stockholders representing at least the 2/3 of the outstanding capital stock of each corporation in case of the stock corporation, or at least the 2/3 of the members in case of the non-stock corporation shall be necessary for the approval of such plan. So, masasabi lang natin approve yung plano na to kapag yung mga vote ng stockholders ay at least 2/3 of the outstanding capital stock sa stock corporation to. Sa case to ng stock corporation. Pero sa case naman ng non-stock corporation, dapat 2/3 ng numbers ng 2/3 ng mga members is okay sa kanila. So, approve yung plan. So, in case naman na hindi sang-ayon yung stockholders, pwede siyang mag-exercise ng right of appraisal in accordance with this code, provided that if after the approval by the stockholders of such plan, the board of directors decide to abandon the plan, the right of appraisal shall be extinguished. So, kung hindi naman agree or hindi payag yung stockholders, pwede siyang mag-exercise ng right of appraisal. Pero dapat according siya sa code. So, right of appraisal, mapag-aaralan natin yan later. So, pero, kapag after ng approval ng mga stockholders doon sa plano at nag-decide yung mga board of directors na iwanan or hindi na lang ituloy yung plano, so yung right ng appraisal ng stockholders is mawawala rin. Any amendment to the plan of the merger or consolidation may be made provided that it was approved by a majority vote of the respective BOD or trustees, ratified by the affirmative vote of stockholders representing at least 2/3 of the outstanding capital stock or of 2/3 of the members. Such plan, together with any amendment, shall be considered as the agreement or merger or consolidation. So, in case naman kung meron mang amendment sa plano ng merger or consolidation, pwede itong mangyari. Provided naman na dapat na-approbahan ito ng majority vote ng mga respective BOD or trustees, and na-ratified yung affirmative vote ng stockholders representing at least the 2/3 of the outstanding stock or the 2/3 of the members. So, such plan, together with any amendment, shall be considered as the agreement or merger of consolidation. So, that is also according or under Section 76. So, paano ba nalaman natin na effective na yung plan of merger or consolidation? Kapag nagbigay na yung SEC, SEC or Security Exchange Commission ng Certificate of Merger or Consolidation.
Section 77, Articles of Merger or Consolidation. After the plan of merger or consolidation has been approved by the stockholders and members as required in Article 76 of this code, the surviving constituent corporation shall execute the articles of merger, while the articles of consolidation shall be executed by the consolidated corporation or the two corporations unite to form a new corporation. And these articles should be signed by the President or Vice President and certified by the Secretary or the Assistant Secretary of each corporation, setting forth the following. First, the plan of the merger or the plan of consolidation. Second, in stock corporation, the number of shares outstanding, and in non-stock corporation, the number of members. Third, in stock corporation, the number of shares voting for or against the plan, and in non-stock corporation, the number of members voting for or against the plan. In the old code, only these three are mentioned, while in the revised corporation code, we have 7. The fourth one, the carrying amounts and fair values of the assets and liabilities of the respective companies as of the agreed cut-off date. Fifth, the method to be used in the merger or consolidation of accounts of the companies. Sixth, the provisional or pro forma values as merged or consolidated using the accounting method. Lastly, the information as may be prescribed by the Commission. Section 78, Effectivity of Merger or Consolidation. After the execution of the articles of merger or consolidation, it shall be submitted to the Securities and Exchange Commission for its approval. If the SEC is satisfied that the merger or consolidation of the corporations concerned is consistent with the provisions of this code and existing laws, mag-i-issue sila ng certificate approving the articles and plan of merger or consolidation. And that's the time that the merger or consolidation will take its effect. However, if the Commission has reason to believe that the proposed merger or consolidation is inconsistent or contrary with the provisions of this code and existing laws, upon proper investigation, the Commission shall set a hearing to give the corporations concerned the opportunity to be heard, and the notice shall be written and be given to each constituent corporation at least 2 weeks before the said hearing. In case of merger or consolidation of special corporations governed by special laws, the favorable recommendation of the appropriate government shall be first obtained. Section 79, Effects of Merger or Consolidation. The first effect is the constituent corporation shall become a single corporation. In merger, the surviving corporation is designated in the plan of merger, while in consolidation, the consolidated corporation is designated in the plan of consolidation. Second is the separate existence or the juridical personality of the constituent corporation shall cease, except the surviving or the consolidated corporation, because in merger, the absorbed corporation will be terminated. In the illustration, as mentioned by Ms. Bonifacio, A plus B is equals to A or B. So either of the two will be terminated or will continue its existence, while in consolidation, the two or more combined or united corporations will cease to exist as separate entities, and the new corporation, or what we call consolidated corporation, will exist. Third, since the surviving or the consolidated corporation have acquired juridical personality, it shall possess all the rights, privileges, immunities, and powers, and shall be subject to all the duties and liabilities of a corporation organized under this code. The fourth effect, the surviving or the consolidated corporation shall possess all the rights, privileges, immunities, and franchises of each constituent corporation, and all real or personal property, all receivables due on whatever account, including subscriptions to shares and other choses in action, and every other interest of, belonging to, or due to each constituent corporation shall be deemed transferred to and vested in such surviving or consolidated corporation without further act or deed. Lastly, the surviving or consolidated corporation shall be responsible for all the liabilities and obligations of each constituent corporation. Also, action or proceeding brought by or against any constituent corporation may be prosecuted by or against the surviving or consolidated corporations.
Let's talk about Title 10, Appraisal Right. What is Appraisal Right? Ano ba itong Appraisal Right? Appraisal Right is a statutory right of a corporation shareholders to have a judicial proceeding or independent valuator determine a fair stock price and oblige the acquiring corporation to purchase shares at that price. Also, it is a protection policy for shareholders, preventing corporations involved in a merger from paying less than the company is worth to the shareholders. Ibig sabihin, appraisal right is the right of every shareholders to vote kung mag-allow ba sila or mag-against sa proposed transaction of the corporation. Or they will ensure the fair market value that will be paid to the shareholders para lamang ma-prevent ang corporation from any losses upon entering the proposed transaction. So since there is a appraisal right, when the right of appraisal may be exercised. According to Section 80, when it be exercised, there are 4 cases and situations that the right of appraisal may be exercised by the shareholders. Number 1, in case of amendment or the articles of the incorporation. So kung may amendment na magaganap of the incorporation, then right of appraisal may be exercised. Second, in case of sale, lease, exchange, transfer, mortgage, pledge, or other disposition of all or substantially all of the corporate property and assets as provided in this code. So kung may sale, lease na magaganap, exchange, transfer, mortgage, pledge, and other disposition, then mag-vote ang shareholder or they will exercise the right of appraisal kung mag-allow ba sila or mag-against na mag-sell ng property or assets ng corporation. Third, in case of merger and consolidation. So ito yung pinaka-major na case or situation na ma-exercise talaga ang right of appraisal ng isang shareholder in case of merger and consolidation. So kasi hindi basta-basta mag-implement ang corporation na makipag-merge sa ibang corporation or makipag-consolidate sa ibang corporation without the consent of other shareholders. Kaya dito na case, ma-exercise talaga ang right of appraisal ng isang shareholders. Number 4, in case of investment of corporate funds for any purpose other than primary purpose of the corporation. So, sa ibang purpose ng corporation which is involving investment of corporate funds, so may exercise pa rin ang right of appraisal ng isang shareholder. So, since there is when do the right of appraisal may be exercised, there is also how the right is exercised. Paano ito may exercise? How? It says here, the dissenting stockholder who votes against the proposed corporate action may be exercised the right of appraisal by making a written demand on the corporation for the payment of the fair value of shares held. So, para ma-exercise ang appraisal right, the dissenting stockholder must prepare or must make a written demand on the corporation. So, written demand ang kanyang gagawin para ma-exercise ang kanyang right. It says here, 30 days from the date in which the vote is taken, provided the failure to make demand within the period shall deemed waiver. So, kapag hindi nakapag-demand ang isang stockholder or dissenting stockholder, then the demand within the period shall deemed waiver. Also, if within 60 days the withdrawing stockholder and the corporation cannot agree on the fair value of the shares within 60 days. Lastly, appraisal shall be final and also reward will be within 30 days. So, paano ma-exercise ang right ng isang stockholder? It is here that the dissenting stockholder who votes against the proposed corporate action may exercise the right of appraisal by making written demand on the corporation. Written demand of the corporation for the payment of the fair value of shares held.
So we are now in Title 10, Appraisal Rights, Section 82, the effect of demand and termination of appraisal rights. So when a decent shareholder ay aalis na sa corporation because of instances action ni corporation under Section 80 with exercising his appraisal rights, what would happen is that all accrued rights, that includes the voting rights and the dividend rights of a decent shareholder, will now become suspended. So take note that the suspension of all rights accruing will start upon the time na si decent shareholder ay magdidemanda ng payment kay corporation hanggang sa time na siya ay mabayaran nito, or si corporation inabandona niya ang kaniyang actions na makikita natin sa Section 80. Also, the shareholder is entitled to receive payments at what? At fair market value. Either agree kung si decent shareholder at si corporation ay nagkasundo sila sa fair market value ng share. At kapag hindi naman sila nagkasundo sa fair market value ng share, i-determine ito ng mga appraiser. So sila yung magde-determine kung magkano ang fair market value ng shares. So, in terms of payment naman, if the decent shareholder was not paid within 30 days after the reward, the voting rights and the dividend rights will become immediately restored. So, if siya naman ay bayad na, then all his rights will become terminated na kasi binili na ni corporation yung kanyang mga shares. So, if before payment naman, hindi na tinuloy ni corporation ang kaniyang proposed action, example, hindi na lang tinuloy ni corporation ang merger. So, the rights and the status of a shareholder will now become permanent restored. It is because there is no reason for a decent shareholder to exercise his appraisal rights kay hindi na tinuloy ni corporation ang kanyang proposed action. So, we are now in Section 83, when the right to payment cease. So, it will only cease if the shareholder withdraw his demand of payment with the consent of a corporation. So, ayaw ni shareholder ng actions ni corporation under Section 80. So, example natin, ayaw niya ng merger. Ayaw ni shareholder na gumawa sa ginagawang action ni corporation na mag-merger. So, gumawa siya ng written demand of payment for his shares and exercise his appraisal rights. And along the way, nagbago yung isip niya. So, sinabi niya na okay na sa kaniya ang merger. So, withdraw niya ang kaniyang written demand of payment tapos kinonsinti siya ni corporation. So, that's the time na ang kaniyang appraisal rights will now become extinguished. So it will become cease. Number 2 naman is the proposed action was abandoned or resigned by the corporation. So, hindi tinuloy ni corporation ang kaniyang proposed action in which si shareholder ay nagdi-dissent. So, his appraisal rights will now become ceased because there is no reason to exercise appraisal rights dahil ang proposed action na nga was abandoned na. Number 3 naman, yung proposed action ni corporation ay disapproved by SEC. And number 4 naman, lastly, so na-determine ni SEC na si shareholder ay hindi entitled for appraisal rights.
As we continue in section 84, Hober's cost of appraisal. So, the costs and expenses of appraisal shall be borne by the corporation. So, ang mag-bear sa cost of appraisal, all the expenses and costs is the corporation. Unless kung ang fair value ascertained by the appraisers is approximately the same as the price which the corporation may have offered to pay the stockholder. So, in case nga on that action to recover such fair value, all costs and expenses shall be assessed against the corporation unless the refusal of the stockholders to receive payment was unjustified. And in section 85, notation on certificate rights of transferee. So, within 10 days after demanding payment for shares held, a dissenting stockholder should submit the certificate. So, dapat within 10 days after nga mahatag na ang mag-demand na og payment, the dissenting stockholder shall submit certificate representing the shares to the corporation for notation. And then, failure to do so, the corporation will opt to terminate their rights. If shares represented by the certificate bearing such notation are transferred and the certificate consequently cancelled, the rights of the transferor as dissenting stockholder under this title shall be ceased. So, kung dili to nila mahatag and then makancel na ang certificate, the rights of the transferor will cease. And then,
ang mahitabuan ni the transferee shall have all the rights to distribute dividends to the regular stockholders. So the transferee would have accrued until shares shall be paid.